Welcome to the Article 6 Combat Manual, Winning Your Right to a Fair Trial. This course exists because too many people walk into court not knowing the rules well enough to catch the moment those rules get broken. That ends here. Over the next few minutes, I'll show you exactly what this manual unlocks for you and how we're going to get there together. So here's what you'll walk away with from this lesson. First, you'll know exactly what this manual is designed to help you achieve. Second, you'll get the full roadmap of the 5 modules and why the order matters. And third, you'll commit to actually doing the action steps, because that's what turns knowledge into something you can use in a real courtroom. I'm one of the independent legal analysts behind LawBeat Radio. We spend our time exposing judicial incompetence and fighting procedural violations wherever we find them. In courtrooms, in filings, in the fine print judges hope nobody reads. This course is built so you can catch violations the moment they happen. It's not theory for theory's sake. It's a manual for people who are in the fight or about to be, and everything here is meant to be used. Here's the roadmap. Module 1 lays the foundation, what Article 6 actually guarantees. Module 2 teaches you to spot procedural manipulation as it happens. Module 3 dives into fabricated evidence, testing it and exposing the red flags. Module 4 is tactical, demanding compliance while your case is still live. And Module 5 pulls it all together, turning defense into offense so you can actually win. Now, go through these modules in order. They build on each other, and skipping ahead will cost you context you need later. It's tempting to jump straight to the tactical stuff in Module 4, or the offense in Module 5, but those only click once you understand the foundation and how manipulation works. Treat the sequence as deliberate, because each module hands you what you need for the next. Every lesson ends with action steps, and here's the deal. Do them. Reading about procedural defense won't help you in a courtroom. Practicing it will. You can know every principle in this manual, and still freeze when a violation happens in front of you unless you've rehearsed the response. Those steps aren't optional homework. They're the whole point of this course. Let's tie this together. This course exists to help you catch the exact moment your fair trial rights get violated. The 5 modules carry you from understanding those rights all the way to turning defense into offense. Work through them in order, since each one builds on the last. And practicing procedural defense, not just reading about it, is what actually prepares you for the courtroom. So before you move to Module 1, here's what to do today. Approach this course like a fighter preparing for a real courtroom, not a student reading for interest. Start with Module 1 and resist jumping ahead. And finish the action step at the end of every lesson before you move on. Get those 3 habits locked in, and let's get to work. Welcome back. Today, we're cracking open Article 6, and here's the thing most people miss. It's not one right. It's 3 separate guarantees bundled together. Courts count on you not knowing where one ends and the next begins. Once you can name which guarantee just got violated, you can actually object to it. That's the skill this lesson hands you. By the end of this lesson, you'll be able to sort any violation into one of 3 buckets on the spot. You'll know the tells for delay tactics, presumption of guilt language, and defense rights stalling. And you'll walk away knowing how to draft a written objection that names the provision and demands a remedy, plus build a dated log that protects you on appeal. Every abuse you've experienced fits into one of 3 buckets. How long your case drags on, whether you're treated as guilty before proof, or whether you actually got the tools to defend yourself. Learn these buckets and you start spotting violations in real time, instead of realizing months later that it's too late to fix. Naming the bucket is what lets you object. Article 6.1 guarantees a hearing within a reasonable time, but here's the trap. It's often paired with rigid filing deadlines. Authorities slow-walk disclosure or reschedule hearings, running out your clock while doing nothing technically wrong on paper. Your defense is tracking every date, and if you're near a deadline still missing documents, file a placeholder objection anyway. Defective on the record beats perfect and too late. Article 6.2 says you're innocent until proven guilty. In practice, proceedings often run backward. The accusation gets treated as established fact. Listen for the defendant did X instead of is alleged to have done X. Watch for sanctions imposed on the charge alone. Silence reads as agreement, so you have to object on the record every single time, not complain about it afterward. Article 6.3 covers your minimum defense rights. Knowing the charges, time to prepare, seeing the evidence, cross-examining witnesses, getting a lawyer. The attack rarely looks dramatic. It's small half-answers. That evidence is still being processed, stacked one after another. Alone, each looks reasonable. Together, they add up to trial by ambush. And the system calls it due process. Sit with that for a second. It doesn't matter how unfair something felt in the moment if you never put it in writing. Every objection you skip is a gift to the other side's clean record. This is exactly why naming the violation and documenting it matters more than your gut reaction. Let's pull it together. Article 6 splits into 3 separate guarantees, not one vague promise. Article 6.1 protects your reasonable time right, but delay gets weaponized against you. Article 6.2 presumes innocence, though many proceedings quietly run backward. Article 6.3 guarantees defense tools, chipped away through small stalls. And underneath it all, you've been trained to treat these as normal. They're not. Here's your homework. Learn the 3 buckets cold so you can label a violation the instant it happens. Track every date and file a placeholder objection near any deadline. Object on the record every time guilt gets assumed. And challenge each delay or half-answer individually, so the pattern of trial by ambush is documented, not just felt. Welcome back. Here's a fact most defendants never act on. You don't have to prove anything. Not your innocence, not your alibi, not your version of events. In this lesson, we're breaking down what Article 6 actually guarantees you, and how to stop carrying a burden that was never yours in the first place. So, here's what we're covering. First, keeping the burden of proof squarely on the prosecution, where it belongs. Second, spotting and shutting down informal burden shifting when it happens in your case. Third, telling real proof beyond reasonable doubt, apart from speculation dressed up as evidence. And fourth, protecting your right to silence from ever being twisted into an admission. Let's start here. You prove nothing. The prosecution carries the entire weight of proving you guilty. That's not a courtesy. It's a binding right under Article 6, Paragraph 2. The moment you start acting like you need to prove your innocence, you've handed the court a burden that was never yours. Don't build a counter-story. Your job is to make the prosecution's story collapse under its own weight by attacking its weak points. Now, the burden never shifts. From the first accusation to the final verdict, it stays on the prosecution. If a judge asks you to explain gaps in their case, that's a red flag, and watch for lines like, "Why don't you explain this?" That sounds reasonable, but it's a direct violation of Article 6.2. Name it and object out loud, on the record, every single time. Next, reasonable doubt is supposed to be a high bar. Too often, courts quietly turn it into any doubt we bothered to consider. Phrases like consistent with or could have happened are guesswork, not proof. A missing timestamp, a changed story, an unverified chain of custody. Treat those as real gaps, not details to explain away with narrative logic. Fourth, your silence is a protected right, full stop. It cannot be used as proof of guilt, legally or otherwise. If a prosecutor implies your silence means guilt, object immediately and get it noted on the record. Strike, he didn't deny it, wherever it appears unchallenged. And if he stayed silent during questioning, that was never a mistake. Don't let anyone, including yourself, reframe it that way. Now, let's turn this into action. Start logging every moment you were asked to explain or prove something. That's a burden shift, and each one needs a one-line objection ready. Mark any evidence built on assumption or consistent with language. And document every time your silence got used against you. This paperwork is what separates a defense that holds up from one that doesn't. Let's lock this in. You're never required to prove your innocence. That burden stays on the prosecution, start to finish. Beyond reasonable doubt is a high bar, and corrupt courts will try to shrink it into guesswork. Don't let them. Your silence is protected and can't be used against you. Now it's time to turn all of this into concrete documentation and objections for your own case. Let's lock in your action steps for this lesson. First, stop trying to prove your innocence and start exposing where the prosecution's case completely falls apart. Second, whenever they try to make you fill in their gaps, drop an on-the-record objection reminding the court where the burden of proof actually lies. Third, when they hide behind weasel words like consistent with or could have happened, force them to show what evidence excludes every reasonable alternative. And fourth, if your silence was twisted against you, file an immediate written demand stating for the record that silence is a protected right, not an admission of guilt. Put these steps into practice, and don't stop here. For full case breakdowns, deeper analytical guides, and real-time strategies against procedural abuse, head straight over to www.lawbeatradio.com. Grab the tools you need and stay ahead of them.